General and affirmative defenses when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagot.com. Your advantage if you're being sued by debt collectors. This is going to be a brief video because I don't want to put it with the videos on answers or counterclaims because they were already too long. When we get to the part about affirmative defenses, though, just remember that you will follow the same pleading rules that you would for a counterclaim. I'll clarify that for you in a bit. A general defense is either a simple denial of the facts, remember our answer, or an argument that the law doesn't entitle the plaintiff to anything. Very basic. And the effect of a defense is to require the plaintiff to prove its case. They say you owe money, and how much, you deny, and it's up to them to prove it. Of course, if you admit owing, either directly in your answer, by testimony, or by failing to answer, you make their job easy, right? An affirmative defense is more complicated. There you are saying that even if you would have owed them money, you don't because... And probably the most common affirmative defense is called accord and satisfaction. That's the fancy legal way of saying that they said if you would pay them X amount of dollars, they'd take it and call it quits. You settled, in other words. But another affirmative defense would be called laches, which means they waited too long to sue you after you stopped paying them, so that you got rid of some records or lost them or something and have been prejudiced or negatively affected by the amount of delay. You don't have to choose between defenses and affirmative defenses. You make them all. Even if you settled with the debt collector before, you can still dispute whether you ever owed the money. You just want to make sure they prove everything. The statute of limitations defense is somewhere in between a general defense and an affirmative defense. They're supposed to show the debt is still good, but you should show it isn't if it's beyond the statute of limitations. So you should probably plead it when we get to that. And remember that the statute of limitations is also a counterclaim. They aren't allowed to sue you for debts that are too old. The point about affirmative defenses is that you have to plead them and prove the facts of them. And in a fact-pleading state, you have to allege the facts that specifically give you the defense. That's really what an affirmative defense means, that it's up to you to raise. The burden of proof is on the plaintiff to prove its case when you simply defend. But the burden of proof is on you to prove affirmative defenses that you raise. That's not usually a big deal, though, if you have any evidence. If you're going to make an affirmative defense, which you definitely should if you have one to make, you will follow the pleading rules for your court. I discussed them in the counterclaims video. You either have to give them general notice of what you're saying in some courts, or, and this is usual, you have to say exactly what facts amount to your defense. If they want to attack your affirmative defenses, or if you want to attack their affirmative defenses to your counterclaim, you do that by what's called a motion to strike, which is really just the same as a motion to dismiss. This stuff isn't really as complicated as it may sound. Take a look at my site. There will be an article on affirmative defenses there for you to read if you need it. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well, so use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallagot.com. Get my litigation manual and forms, and defend yourself from the debt collectors.